ask, how grievous really is tax evasion? What does the law say about it? And is it enough really to stop someone who is vying for an elective post?
I think the first point to make very, very clearly is that somebody who's standing for an elective post is supposed to be above board in terms of character.
All right.
And in terms of morality. So if there's any allegation bordering on any impropriety, or whether on criminality, that questions his credibility as a candidate. He puts his character in issue. And the law envisages, and again, somebody who is standing for election is supposed to be honest and integrity driven.
Okay.
Whatever information he furnishes to the electoral body must be true and correct in all material respects. That is why under the Constitution, there are provisions for qualifications of candidates. And these are further strengthened by the provisions of the Electoral Act, demanding that persons who are contesting for elections must have certain prerequisites, including qualification and moral standing. So the issue of tax evasion, when viewed from this perspective, is very critical. And that is why the Electoral Act also says in section 31 down to 37 that if before the primaries a candidate has any information, that is any of his co-contestants has filled certain informations in his forms that is not correct, or has falsified information, then you are at liberty. Somebody you are running an election with, you are at liberty to challenge the candidacy
of that person based on that. Okay.
And it will be treated as a pre-election matter. Pre-election matter. And in this analysis, in this whole analysis, as I will demonstrate, and my colleague also will demonstrate, you will see that there's a distinction between a pre-election matter and election matter, as well as a post-election matter. There are various stages in the electoral processes. And when there are violations or infractions, they have different consequences. And speaking specifically on this issue, on this one that you have asked, whether somebody who is accused of tax evasion can be challenged. I'll enter a caveat, provided the information is correct, that the man indeed. I've seen from, responses of the main antagonists, the one is alleging that there is tax evasion, there is false information in respect of the tax furnished by Ikpeazu. Ikpeazu is contending that there was no such falsity.
Because I want to stay on that, because just recently the Abia State Internal Revenue Service released a statement saying the tax statement was not actually falsified, that is actually authentic. But my issue now, my question would be that why now, during the process of the court sitting and all of that, how come it was not really established?
You see, you have to follow the history of this particular case. This particular case has been pending before the election, the main general election that brought Ikpeazu to power. Ogah ran as a candidate with Ikpeazu and some other contestants under the platform of PDP.
Yes.
For the nomination of the candidate of PDP for that election. He came second. Ikpeazu won that primaries. After that, the primaries was declared, the result was declared, he went to court, to the Federal High Court precisely, to say that the man who won the primary was not qualified to run for that position, and that PDP should not present him as the candidate of the party by virtue of the fact that he falsified information contained in his declaration to the party. The party has guidelines, and that matter was brought before the Federal High Court, because by virtue of section 31 of the Electoral Act, when you have a pre-election dispute of such a nature, challenge before the election, main election actually takes place, you either approach a federal high court or a high court of a state. The two of them have coordinate jurisdiction on that issue to say that, oh, this, and if the court finds as a fact that what you have said is correct, then the court will then be at liberty to disqualify the candidate, in which case the person who has then petitioned will now emerge as the candidate of the party. But in this case, when the man, after the primary result of the primary was declared, when Ogah approached the court, Ikpeazu then challenged the jurisdiction of the court to entertain the matter, that the Federal High Court had no jurisdiction to entertain that matter. And this matter, this issue of jurisdiction was resolved. I mean, the trial court ruled that he has jurisdiction, and they further appealed down to the Supreme Court. And the Supreme Court held, because the court heard that the trial court had jurisdiction, I mean the Federal High Court had jurisdiction to try that matter. And then ordered the trial court to commence the process of trial of that matter on the merits. Because the Supreme Court will not try, the Supreme Court was resolving the issue of jurisdiction. Whether or not the Federal Court had jurisdiction, that means the competence to determine that matter. Now, the Supreme Court found as a fact that the Federal High Court, by virtue of the Electoral Act, had jurisdiction. And that the Federal High Court should now proceed, after having determined the issue of jurisdiction, to determine the merits of that matter, on the merits. To determine that case on the merits. And the file was then remitted back to the Federal High Court in order to be able to determine the merits of the case, whether the issue of falsification of tax by Ikpeazu was actually correct.
Okay.
So after a protracted trial process, the court found as a fact that Ikpeazu actually falsified his tax payment, and then ordered, by the time this verdict came, the general election had taken place. Ikpeazu had contested as a candidate of PDP against some other candidates from other parties and had emerged as the governor. So what the court then directed INEC to do is that they should issue certificate of return to Ogah, who came second in the PDP primaries, as the governor, as the person who ought to have been presented by PDP, by virtue of the fact that the allegation he raised is correct. And that, so Ogah should be given the certificate of return. So, and you know, by law, once a certificate of return has been given to a candidate, and another one is issued again, the one that is issued later on supersedes
the one before. Okay.
And then the Federal, I mean, the INEC was acting based on the directive of the Federal High Court. But just before, after that order came from the Federal High Court directing that INEC issues a new certificate of return to Ogah, a court in Abia ruled, based on ex parte application brought before it, that Ogah should not be sworn in
as governor.
As governor. Those are the preliminary facts.
All right. Now, we'll come back to the issues, you know, regarding all of that. But I still want us to talk a bit about the tax papers. Now, Barrister Adaramoye, the main issue of contention here is the fact that the tax papers were dated on a Saturday. Does this in any way invalidate Ikpeazu's tax papers?
Actually, when you look at it, the issue of Saturday, ordinarily, there are a lot of interpretations to that. When you look at Lagos State High Court rules, things that are done, Saturday actually are not part of public holiday, all things being equal. But I say some jurisdiction depends upon what the civil procedure rules state there. Because what is recognized as public holidays, you know, in I mean, as public holiday in our legal system, Christmas, Good Friday, El Madrid and other kind of stuff. Those are the ones that are recognized as public holiday.
Easter, Workers'
Yes,
Day, and the
all
rest
those
of them.
things.
Yeah.
So, but beyond that, my own view about the issue matter is a very controversial, complex matter. My own view, when you are alleging that a serious issue like falsification of tax papers, I think ordinarily it borders on forgery and it's a serious matter. Actually, I've had cause to dig into the matter and I look at it fundamentally. I discover that a matter of such magnitude in law, bordering on crime, I really think that the procedure ordinarily wouldn't have been through originating someone, because ordinarily it is a contentious matter. And when you have a contentious matter, the parties that are involved, you have to give evidence, you have to call people to give evidence to that, because it is a serious matter. Like he rightly said, in order to sanitize our legal environment, ordinarily, we are supposed not to have criminals, charlatans, you know, and all those dubious elements that parade themselves as our leader. When you are talking about leadership, it is something that is made of external stuff. Ordinarily, we are supposed to have people that can lay claim to sanity when it comes to moral. You know, I think people that their hands are soiled ordinarily are not supposed to come to leadership arena. That has been my view so far. But, and at the same time, laws are supposed to be followed. When you look at what actually happened, this matter resulted from 2014 PDP election. You know, when you look at our justice system, all things being equal, one will have asked that this kind of matter ought to have been resolved before presenting candidates for that election.
Yes.
Because ordinarily, some people actually may term it as a pre-election matter, even though there is an authority.
Because in the first place, there's a process to follow.
Yes.
You know, even as a candidate.
Exactly. Yeah. Ordinarily, I would have expected that that issue will have been resolved before presenting a candidate. I think this is still an area where our lawmakers still have to do a lot of job. Because ordinarily, having presented somebody for an election, only to come back, like what White does. White will appoint invigilators, monitor an election. The invigilator monitors the election. At the end of the day, the result of election is, comes out, only to hear after some years that that election has been cancelled. I think it is an aberration. I think it's an anomaly, because Estopel ordinary wouldn't expect that body to come out and say it's cancelling that organization. That paper. So my view about this thing, in as much as some people have said it's a pre-election matter, there is an authority equally saying it's both pre and post-election, election matter, so to say. So what I'm trying just to say in essence is that before that battle that actually ensued fighting to Supreme Court, I think what a lawmaker should do, if you have a pre-election matter, it has to be determined within a specific time before proceeding. Okay. Otherwise, this kind of solution will continue to have been.
Okay, but as it is right now, since it's actually like a party tussle, struggle as it were, don't you think there should be a bit of a review of the electoral process? Since it was the party who did all the screening and all of that, don't you think it should be some sort of a review where INEC can take a step further to still, review, the candidate as it is?
I think it's a joint problem, you understand, and a joint neglect, all things being equal. Because the party ordinarily ought to have scrutinized the paper that were presented, but more specifically, more importantly, INEC itself has an organ also have looked at those papers, because when you look at it, the role of INEC is very, very paramount in all these things. So in a situation in which something escaped, the prying eye of the, what do you call it, of the party, and that of electoral system, I think is absolutely bad. So in my view, it is my view personally, that such things should be resolved before going to an election. And let me say, some people have been trying to compare with the issue of Amishi. It's quite and radically different from that of Amishi. That of Amishi was declared winner. And Obasanjo came, the president then, and said the case of Amishi had the K-leg. You understand? But in this issue, it's more or less an Hydra-headed monster, because the person that actually came to Odunwosu is laid claim to the crown equally. He has gone. I think the case will be coming up today. You know, the case will be coming up. Because he said, as at the time the election was conducted, Dr. Ogah rejected the result. Neither Ogah, none of his agents actually signed the paper. They didn't sign it. He said the matter, he was the one, because he disclaimed the verdict of the election. And he's contesting that. If you have disclaimed the verdict of the election, how on earth will you come back again and say I want to benefit from what I didn't believe in? He said rather, he should be declared the winner, even though the position of the law does not support him. Because where there is a situation of such nature, what they should ask for is, according to section 142 of the, permit me to read. He said where an election tribunal or court nullify an election on the ground that the person who obtained highest votes was not qualified to contest the election, the election tribunal court shall declare the person with second highest vote, shall not declare the person with the second highest vote as elected, but shall order a fresh election. So to that extent, what his decision is not a point. To that extent, if I have my reservation for that judgment, you understand, he has made an order that is inconsistent with the position of section 140 of the electoral act.
Okay. All right. Now let's come back to you, Barrister Shittu. Upon the court judgment that sacked Ikpeazu from office, he filed an appeal, against the ruling, and of course, a notice of appeal was sent to INEC. Now, I want to ask: is a notice of appeal, is it enough really to stop INEC from issuing a certificate of return to Ogah?
Since we have enlightened audience that we are dealing with, some people out there who are far more better informed than some of us who are seated here, it is important for us to make this distinction.
Okay.
Very, very important. Let me first of all say that whether or not the decision handed down by Justice Akpan was right or wrong, I'm not in a position to say as I sit here. Because every court has the jurisdiction to be right as well as the jurisdiction to be wrong. That we must say. But once a judge has handed down a decision, whether right or wrong, the only authority that can overturn that decision is an appellate court. When we come here, my little friend, for whom I have a lot of respect, has faulted the decision of Justice Akpan on the ground that the issue borders on falsification of tax, and
papers,
that amounting to forgery, like what he said. And forgery requires expert opinion. You understand me? Whether or not it was right for Justice Akpan to decide that based on the affidavit evidence is a matter for the appellate court to decide. But what is critical at this stage is that Justice Akpan has handed down a decision, which by law is binding.
And should be followed to the letter.
That I think we must. Again, for the purpose of the enlightened audience out there, it is important for us to distinguish between pre-election proceedings and election as well as post-election proceedings. Very, very important.
Are there different laws guiding?
There are different laws.
Okay,
different
all
laws.
right.
Pre-election proceedings is governed by section 31 to 37 of the Electoral Act. If you have issues with any of the candidate who is running for election under your party, before a candidate's days is forwarded to INEC,